Imagine a sprawling mega project.
Oh, like a massive infrastructure site.
Yeah, exactly. Like a multi-billion-dollar hydroelectric dam or, one of those skyline-defining skyscrapers. You've got thousands of workers, dozens of specialized teams, and everything is moving like clockwork.
Right. Highly choreographed.
Very. Until suddenly, a single shipment of highly specialized load-bearing steel is delayed at a port half a world away.
Which is a disaster.
It is. The crane just stops turning. The entire critical path of the project completely grinds to a halt. And just like that, a single logistical hiccup triggers a massive, unstoppable cascade of financial claims.
Oh, yeah. Everyone starts pointing fingers immediately.
Right. So the project owner blames the main contractor for missing a milestone. Then the main contractor points a finger at the steel subcontractor. The subcontractor blames the supplier. Before you know it, you have a sovereign wealth fund, a multinational engineering firm, maybe 5 different specialized subcontractors.
Don't forget the architects.
Yes, an architectural design team and a huge syndicate of international banks all scrambling to protect their margins. These are parties who genuinely never intended to be sitting in a room together. And now they're trapped in a multi-billion-dollar mess.
It is honestly the ultimate logistical and financial nightmare.
I can't even imagine the pressure.
It's immense because you have overlapping, incredibly dense contracts, astronomical daily overhead costs, and this ticking clock that threatens to basically bankrupt whoever's left holding the bag.
Oh.
Yeah. By the time that crane actually stops moving, the engineering problem has fully mutated into a legal one.
Which brings us to the mission of our discussion today. We're exploring the hidden, really high-stakes machinery of EPC that is engineering, procurement, and construction dispute resolution.
It is a fascinating world.
It really is. The goal for you listening is to understand exactly how these massive international catastrophes actually get untangled. And, maybe more importantly, why picking the right institution to handle the fallout from day one is arguably the most critical strategic decision a project makes.
Okay, let's unpack this before we get into the specific global venues that handle these disasters. We need to establish the baseline of how they are fought in the first place.
Right, the mechanics of it.
Because anyone looking at this from the outside would naturally assume these giant companies just sue each other in regular court.
I mean, that is the natural assumption, right? Yeah. But in the realm of international mega projects, traditional litigation is virtually non-existent.
Really? Just completely absent?
Pretty much, yeah. Instead, the industry relies entirely on arbitration, which is essentially a privatized justice system. And to understand why they do that, we have to look at the massive friction points of global commerce.
I want to push back on that default choice for a moment, though, because looking at the financial realities from our sources, arbitration seems incredibly counterintuitive. How so?
Well, it is often significantly more expensive than going to public court. I mean, you are paying hourly rates for a tribunal of 3 high-powered private judges, right?
Sure.
Plus, you're paying administrative fees to some institution, and you're footing the bill for a small army of private delay experts. Furthermore, finality is baked into the system. There are practically 0 avenues for a substantive appeal.
That's right.
So if a tribunal misinterprets the contract or they hand you a completely devastating ruling, you are stuck with it. So why would sophisticated, highly risk-averse corporations willingly lock themselves into a system that costs way more and traps them in potentially flawed decisions?
What's fascinating here is that those apparent downsides, the cost, the lack of an appeal, they're actually accepted as necessary trade-offs for 3 overarching benefits.
Okay, what's the first one?
The first is neutrality. Let's say your mega project is a desalination plant being built in a Gulf state.
Okay, got the picture.
You have a French EPC contractor, a South Korean supplier, and the local state-owned employer. If the project just completely implodes, the French contractor is absolutely terrified of litigating in the local Gulf courts.
Oh, sure, fearing home court advantage.
Exactly.
Yeah.
But conversely, the Gulf employer absolutely refuses to fly to Paris to litigate under French civil procedure. So arbitration creates a neutral, mutually agreed upon battleground.
That makes perfect sense. You are essentially buying a neutral referee to just strip away any home field advantage for anybody.
Precisely.
But the neutrality argument only goes so far if the referee doesn't understand the game. Like if you take a delay claim to a national court, a federal or high court judge certainly knows how to interpret contract law.
They know contract law, yes.
Okay.
But an EPC contract isn't just a legal agreement. It's literally a highly technical engineering manual.
That's a good way to put it.
Right. So a generalist civil judge might be brilliant, but they likely spent yesterday adjudicating I don't know, a defamation lawsuit.
Yeah.
And tomorrow they have a complex tax fraud case.
So they aren't specialists.
Not at all. If you dump 10,000 pages of critical path delay analysis, soil liquefaction reports, and forensic engineering data on their desk, they are entirely out of their depth.
I'd be out of my depth, too.
Most people would be.
Yep.
But arbitration allows the parties to handpick a tribunal comprised of dual qualified professionals, people who are not only veteran lawyers, but often former civil engineers or project managers. They deeply understand construction physics.
Which is absolutely vital when the core of the dispute hinges on, say, the tensile strength of that delayed steel we mentioned earlier, or whether a specific weather event actually altered the critical path of the concrete pour.
Exactly. You need someone who speaks the language.
But even with experts, the system has its flaws, right? Our sources highlight a very specific, hotly debated phenomenon in practitioner circles regarding how these private arbitrators actually rule. It's often referred to as splitting the baby.
Ah, yes. The King Solomon dilemma. Because arbitrators operate in a highly competitive private marketplace where they rely on repeat appointments from law firms, there's this pervasive anxiety that they naturally gravitate toward compromise.
So they don't want to make anyone too mad.
That's the fear. That instead of issuing a ruthless, clear-cut ruling that completely vindicates one party and financially destroys the other, a tribunal might try to soften the blow.
Just to keep the peace.
Kind of. They might award the contractor a portion of their delay costs, while giving the employer some of their liquidated damages, keeping everyone somewhat satisfied, but ultimately frustrated.
It's the ultimate hedge. I mean, you don't want a reputation as an arbitrator who drops the hammer too hard, or half the industry will just strike you from their selection lists.
Exactly.
But even acknowledging that risk and the astronomical costs, there is a fundamental mechanical reason why arbitration is really the only option. It comes down to enforcement.
Precisely. The New York Convention of 1958. This is the absolute bedrock of international commerce.
How so?
Well, if you win a multi-million-dollar judgment in a domestic court in, let's say, London, taking that piece of paper to South America and asking their local police to seize a contractor's assets is an agonizing, often impossible diplomatic nightmare.
I can imagine. Lots of red tape.
Huge amounts of red tape.
But under the New York Convention, an arbitral award is recognized as a binding obligation in over 170 countries.
Yes, almost everywhere that matters commercially.
So you can take an arbitration ruling from Paris and enforce it against a bank account in Tokyo or real estate in Brazil with minimal judicial interference.
Without that guarantee of cross-border collection, international banks simply would not finance these infrastructure projects.
The financing would evaporate overnight.
It really would. So that establishes the why. Arbitration is the mandatory vehicle, but the real strategic nuance lies in the where.
Exactly. When you draft the contract, you have to choose which specific arbitral institution will administer the rules of engagement. And comparing the heavyweights reveals just how differently they approach dispute resolution.
It's night and day with some of them.
Let's look at the International Chamber of Commerce, the ICC, based in Paris. In the construction sector, particularly for projects utilizing standard form FIDA contracts, the ICC is widely considered the gold standard.
They are, and the ICC has deliberately cultivated that reputation. They maintain a dedicated commission on arbitration that continuously publishes tailored guidance for construction disputes.
So they are actively studying this stuff.
Constantly. They understand that a massive infrastructure failure operates on a completely different frequency than just a standard commercial breach of contract.
And their primary mechanical advantage is how they handle lateral chaos. Because when a mega project fails, the claims don't just flow vertically between the employer and the main contractor, right? They move sideways.
That's right, the ripple effect.
If the employer sues the main contractor for a massive delay, the main contractor's defense often hinges on proving that a specific subcontractor actually caused the bottleneck, or maybe that an insurance policy should cover the fallout.
Which creates a massive logistical paradox. If you have separate arbitration clauses in the main contract, the subcontract, and the insurance policy.
Oh, I see where this is going.
Yet you could end up fighting 3 distinct battles in 3 completely different rooms.
And that leads to the ultimate disaster: conflicting awards. You could have a tribunal in a room, a rule that you owe the employer $50 million because of the steel delay.
Nightmare.
Then you walk into room B to sue the steel subcontractor to recoup that money, and a completely different tribunal looks at the exact same facts and decides the subcontractor did nothing wrong.
And you are left holding the entire bag.
That is terrifying.
It is. And that is the exact scenario the ICC rules are built to prevent. The ICC has exceptionally powerful mechanisms for multi-party joinder and multi-contract consolidation.
Basically merging it all together.
Essentially, yes.
Yeah.
Their rulebook allows the tribunal, under the right conditions, to basically drag that subcontractor and that insurer into the primary arbitration, even if they originally signed separate contracts. They are industry leaders at fusing these disparate overlapping agreements into one massive, coherent proceeding, so that a single tribunal hears all the evidence and issues a unified, logically consistent ruling.
So if you anticipate a sprawling, multi-party tangled web, the ICC in Paris provides the structural framework to consolidate it.
Exactly.
But what if complexity isn't your primary threat? What if the real danger is a bad faith counterpart who simply wants to bleed you dry through financial attrition?
That's a very real threat.
That requires a pivot to a different kind of venue. The LCIA, the London Court of International Arbitration.
The LCIA is fascinating because it operates within the framework of English common law, which has historically been the governing law of choice for complex global energy, oil, gas, and maritime projects.
But there is a glaring operational difference with the LCIA. We just spent time establishing that technical expertise is the cornerstone of construction arbitration. Yet the sources note the LCIA does not maintain a dedicated, specialized panel of construction arbitrators like the ICC or other venues do.
Right, they don't.
They rely on their general commercial roster. To me, that seems like a massive vulnerability. How do they effectively manage a highly technical dispute over, say, the thermodynamics of a renewable energy plant without a specialized bench?
They compensate for that lack of a specialized roster through sheer procedural muscle.
Procedural muscle.
Yes.
Yeah.
The LCIA rulebook is designed for intense, heavy-handed case management. The institution gives its tribunals incredibly sharp teeth to clamp down on the exact kind of bad faith tactics you just mentioned.
When we talk about procedural muscle in this context, I'm assuming that means the tribunal actively polices the behavior of the lawyers, because in a lot of these disputes, one side knows they are going to lose, so they just weaponize the process.
Oh, absolutely. They throw sand in the gears.
Right. They demand millions of irrelevant documents. They delay witness statements. They try to stretch a 2-year process into 5 years, hoping the other side simply runs out of capital and settles.
Precisely. And the LCIA rules empower arbitrators to shut that down aggressively. For instance, they have very clear, robust mechanisms to order what's called security for costs.
What does that look like in practice?
Well, if a tribunal suspects a party is dragging out the proceedings while secretly shifting assets to avoid paying a future judgment.
Sneaky.
Very. The tribunal can actually force that party to deposit millions of dollars into an escrow account just for the privilege of continuing the arbitration.
Oh, that is a brilliant mechanism. It instantly calls their bluff, because if you don't have the cash to put in escrow, your delay tactics are cut short.
Exactly. It forces discipline. The LCIA also gives tribunals explicit authority to expedite the formation of the tribunal itself and to heavily restrict the scope of document discovery. They treat procedural efficiency as a mandate, not a suggestion.
So Paris untangles the complex web, and London brings the procedural hammer down on runaway costs and bad faith.
That's a good way to summarize it.
But both of those processes, even when managed well, take years. And when we look at the sheer volume of concrete pouring into the Asia-Pacific region right now, the primary existential threat to a project isn't always legal complexity, it's time.
Oh, time is everything.
Here's where it gets really interesting. The infrastructure boom across Asia has completely shifted the center of gravity for global disputes.
It has. And if you are pouring concrete, time is quite literally cash.
Let's look at SIS, the Singapore International Arbitration Center. Their entire operational identity in the construction space is built around velocity.
Speed is their calling card.
Right. Because on a live construction site, you cannot wait 3 years for a final award. If a payment dispute freezes cash flow, or a contractor is physically locked out of a site by a hostile employer, the contractor will be insolvent in a matter of months.
The project will just completely suffocate.
Yeah.
So to solve this, SIAC has heavily refined its emergency arbitrator provisions. Think of this as the arbitration equivalent of seeking a temporary restraining order or an emergency injunction in a public court.
How does that actually function in reality, though? Because usually just selecting the 3 arbitrators and clearing their conflict of interest checks takes 2 months.
Well, under SIAC's rules, If you file an urgent application for emergency relief, the institution can appoint a single emergency arbitrator within 24 to 48 hours.
Wow, that's incredibly fast.
It is. And that arbitrator has the authority to issue an interim binding order immediately.
So if an employer illegally calls a massive performance bond, draining the contractor's operating capital, the contractor can go to SIAC, get an emergency arbitrator appointed over the weekend, and secure an order forcing the employer to freeze that bond call by Tuesday.
Exactly. It's that fast. And while emergency arbitrator rules exist in other institutions, SIAC's administrative machinery is arguably the fastest and most relentlessly efficient at executing it.
They've really nailed it.
They have fundamentally mastered the art of providing urgent, project-saving relief to keep the site breathing while the broader multi-year arbitration plays out in the background.
Which makes Singapore the ultimate venue if your primary concern is maintaining cash flow and site access. But staying in Asia, we have to look at the other heavyweight just up the coast, HKIAC, the Hong Kong International Arbitration Center.
A totally different beast.
Right. This institution is deeply intertwined with China's Belt and Road Initiative, which is perhaps the most expansive, multi-layered infrastructure program in modern history.
The Belt and Road projects are incredibly unique because of their scale and the intense vertical integration of the supply chains.
And HKIAC has developed incredibly sophisticated rules to handle the specific architecture of those disputes.
They have.
I was looking at their framework for concurrent hearings and trying to visualize how it works mechanically, because it's different from the ICC's consolidation.
Yeah, it's very different.
Instead of forcing every party into one giant merged lawsuit, which might violate the confidentiality of separate contracts, the arbitrators are essentially running parallel tracks. It's almost like a computer processor running multiple threads using the same cached data.
That's a great analogy.
So the tribunal hears the highly technical evidence for a delay once, but they apply that same evidence to the main contract dispute and the subcontract dispute simultaneously without formally merging the two cases.
That is an excellent way to conceptualize it. Concurrent hearings allow the tribunal to track the vertical cascade of a dispute. So, employer to contractor to subcontractor with total factual consistency.
Without repeating everything.
Exactly. They don't have to listen to the same delay expert testify 3 separate times and 3 separate arbitrations. It saves an immense amount of time and money while preserving the legal boundaries of the individual contracts.
But there is another specific feature of HKIAC that is utterly crucial for modern mega projects. Their specialized panel of arbitrators explicitly covers both construction and intellectual property.
Yes.
At first glance, IP seems completely irrelevant. We are talking about pouring concrete and laying steel. Why do we need patent lawyers in a construction dispute?
Because modern EPC contracts are no longer just about concrete and steel. They are massive technology transfers.
Oh, interesting.
Think about it. If you are building a next-generation green hydrogen facility, or a state-of-the-art semiconductor fabrication plant, or utilizing proprietary AI-driven tunnel boring machines, the physical construction is deeply intertwined with highly sensitive, patented technology.
So if a dispute erupts over why a specific chemical refining process isn't hitting its output targets, the tribunal isn't just looking at structural engineering. They are analyzing proprietary chemical formulas and licensing agreements.
Precisely. You need a tribunal that is fluent in critical path delay analysis and international patent law. HKIAC has deliberately positioned its roster at that exact, highly complex intersection, making it the premier choice for tech-heavy infrastructure projects.
That perfectly frames the Asian landscape. Singapore for emergency velocity and Hong Kong for multi-tier high-tech infrastructure.
Exactly.
But to complete the global picture, we have to transition to the region where some of the most ambitious, gravity-defying projects on Earth are currently rising. The Middle East. This brings us to DIAC, the Dubai International Arbitration Center.
DIAC represents a fundamentally different philosophical approach to dispute resolution.
How so?
It has to. The legal and cultural landscape of the Middle East requires a venue that can seamlessly blend modern international arbitration mechanics with the specific principles of regional civil codes.
The thing that immediately stands out about DIAC's framework is their approach to mediation. Because in Western venues, mediation is often just a polite suggestion.
Right, totally optional.
But under many Middle Eastern contracts and DIAC frameworks, there are mandatory conciliation and mediation windows. These are legally required steps that parties must exhaust before they are even allowed to officially initiate the arbitration.
If we connect this to the bigger picture, it highlights a crucial cultural divergence in how business is conducted. In many Western legal traditions, the moment a major breach occurs, the immediate reaction is adversarial warfare.
Shields up, lawyers out.
Exactly. The relationship is considered dead, and the goal is just financial recovery.
But in the Gulf, it's different. It's almost like mandated couples therapy before you are legally permitted to file for divorce. You have to sit in a room and actively try to save the commercial relationship.
That's a really good way to frame it. Regional civil codes in the Middle East place a heavy, codified emphasis on the principle of good faith in contract execution.
So it's not just a nice idea, it's the law.
Yes, preserving the commercial partnership and finding a face-saving, mutually agreeable solution is highly prioritized. DIA's rules are fully modernized. They have emergency relief and consolidation provisions, just like Paris or Singapore, but they deeply respect that local cultural nuance.
Which is critical because if you are a Western contractor building a sprawling new energy hub in the UAE and you arrogantly try to bypass mediation and drag your local government partner straight to a hostile tribunal in London, you aren't just breaching a contract clause, you are deeply offending the local business culture.
Oh, absolutely.
You might win the arbitration, but you will never work in that region again. DIAC provides international standard rigor, but with a local pool of experts who possess that vital regional fluency.
It is the perfect bridge between global capital and regional legal tradition.
So what does this all mean for the strategic planning of these projects? If you are a project manager, a financier, or in-house counsel analyzing a massive infrastructure deal, the ultimate takeaway is a harsh reality regarding timing.
It really is.
Because by the time that steel shipment is delayed and the first major dispute erupts on site, it is far, far too late to negotiate your venue. This choice has to be hardwired into the contract on day one when everyone is still smiling at the signing ceremony.
It requires extreme foresight. You have to look into the future and ask, what is the specific pathology of how this project is most likely to fail?
Right. Do you anticipate a massive, tangled web of subcontractors where you need the ICC in Paris to force everyone into one room?
Or are you dealing with a potentially hostile counterparty where you need London's LCIA to enforce brutal financial discipline and security for costs?
Exactly. Do you need the sheer 24-hour velocity of Singapore's SIAC to prevent a cash flow death spiral?
Or are you building a proprietary tech-heavy Belt and Road asset that requires Hong Kong's IP expertise and concurrent hearings?
Or do you need the cultural diplomacy and regional civil code fluency of Dubai?
It is arguably the most critical strategic decision you will make, entirely disguised as boilerplate contract language at the very back of the agreement.
It's wild to think about.
It is. But analyzing all these brilliant, highly efficient institutions brings up a rather unsettling question about the industry as a whole. It's something that deserves deep consideration long after our discussion ends.
Oh, let's hear it.
We spent this entire time talking about how one of the primary drivers of arbitration is confidentiality. Corporations love this system because their catastrophic project failures, their engineering miscalculations, and their proprietary design flaws are handled quietly away from the public gaze of a national courtroom.
Right, no bad PR.
Exactly. And as we noted, arbitration creates no binding legal precedent. Every single multi-billion-dollar case is a closed, hermetically sealed loop. But if every collapsed tunnel, every sinking foundation, and every massive logistical breakdown is resolved completely behind closed doors with zero public record, how does the global construction industry actually learn from its most catastrophic mistakes?
Oh, wow. That is a truly haunting thought. We have engineered a flawless, globally enforceable legal machine designed specifically to hide the biggest structural failures in human history from the public record. We are doomed to repeat the mistakes because we legally aren't allowed to study them. That is absolutely going to stick with me the next time I drive past a skyline full of cranes. Well, thank you for joining us on this deep dive into the hidden machinery of global EPC disputes. Keep questioning the structures around you, and we will catch you on the next one.
Thanks for watching. Please subscribe and see you next time.